Hello, I'm Rachel Jones. I'm a staff attorney at Legal Services Vermont, and with me is George Salmons, a paralegal at Legal Services Vermont. Thank you very much for tuning into our video series about consumer bankruptcy. In this segment, we will be going over important information to consider prior to filing bankruptcy and commonly asked questions. In the upcoming segments, we will look more in depth into the bankruptcy process, as well as the aftermath of filing bankruptcy as a consumer.
Thanks, Rachel. So first question is, what is bankruptcy?
So, bankruptcy is a legal process that's held in the federal court that can give people a fresh start, basically by wiping out people's debt. So, once the debts are wiped out through bankruptcy, creditors and collection agencies can no longer try to collect the debts. And really, the goal is to have this fresh start, especially in cases where a person or a family has acquired a lot of debt that just cannot be paid off and is just overwhelming. Now, bankruptcy courts are not found in every county in Vermont. Court is held either in Rutland or in Burlington, depending on where you're located. So it is a bit different than other court processes that have courthouses in every county. Um, and then, really, the end goal of a bankruptcy is to obtain a discharge. So, a bankruptcy discharge is where the debts are wiped out, where a person or a family no longer has the obligation to pay on these debts. And also, a discharge is permanent. So, a creditor or a debt collector cannot come back and try to collect on the debt um, years later if it has been discharged in a bankruptcy court.
Excellent. And so what is the difference between a Chapter 7 and a Chapter 13 bankruptcy?
Thank you. So in this video series, we're going to be primarily covering Chapter 7 bankruptcies. So there are multiple versions of bankruptcy. Some bankruptcies apply to businesses, some apply to consumers, and they are differentiated by chapter. So Chapter 7 and Chapter 13 are bankruptcies for consumers. So the Chapter 7 bankruptcy, in this case, some assets may be protected by exemption laws. And then assets that are not protected or not exempt may be sold off to pay off the creditors. And the Chapter 7 bankruptcy is often ideal in cases where all or most property is covered by the exemption limits and protected through the bankruptcy. Also, keep in mind that the Chapter 7 bankruptcy, you must pass what is called a means test. In this test, you generally have to earn under the median income for your state based on your household size. And most clients who speak with our office easily pass the means test, but that is just something to keep in mind. And if you have questions about that, definitely talk to a bankruptcy attorney. And then a Chapter 13 bankruptcy, on the other hand, this is a 3 to 5 year payment plan that must be approved by the bankruptcy court. And generally, this requires a consistent income. The debtor must show an ability to pay this payment plan over time. And this may be a better option if somebody has important assets, such as a home, that are not covered by the exemption limits, those protections that we discussed. So again, if you're deciding between a Chapter 7 and a 13 bankruptcy, it's a good idea to talk to a bankruptcy attorney to figure out which version would be best for your case.
Excellent. Thank you. Um, how can bankruptcy help someone?
So it's really to have a fresh start. Oftentimes, people who are seeking bankruptcy may have a lot of debt. They may have been having phone calls from debt collectors or letters, and just a lot of stress. So bankruptcy is there. It is a solution um, that aims to wipe out these debts um, and in effect could reduce stress, could stop these um, phone calls, letters, court cases, things like that.
Great. And then uh, does bankruptcy affect my credit score?
So many people are understandably concerned about bankruptcy affecting credit. Some people may be concerned that it would make a credit rating worse, but that isn't necessarily the case. So a person who has a lot of debt may already have poor credit, so it is hard to know whether a bankruptcy would make that credit rating worse. And then also a person can only file a Chapter 7 bankruptcy once every 8 years. So new creditors may view this as a positive. Um, Now, while bankruptcy does last on a credit report for 10 years, new creditors will also see the balance reported as zero. So, and that's once you've gotten a discharge. So creditors are really most interested in what you owe now rather than what you previously owed. Um, so the short answer is it depends. It may not necessarily make somebody's credit rating or credit prospects worse. Now, it may make it more difficult to obtain a mortgage loan to buy a home in the future. But if you establish good credit after filing bankruptcy, your prospects of obtaining a mortgage might improve.
I had no idea. Thanks. Um, so what are some reasons why someone may choose bankruptcy?
Thank you. So in some cases, if you have a lot of debt, let's just say more than 10,000, that might be a good bankruptcy may be a solution for taking care of a very large amount of debt. Maybe you don't own much property, or you don't have assets that are unprotected from the exemption laws, and that may be a case where Chapter 7, a Chapter 7 bankruptcy is an option to consider. Um, you may be dealing with debt collectors or a wage garnishment order, and again, bankruptcy may be a solution for taking care of those issues. Now, there are some reasons why someone might wait to file bankruptcy or not file bankruptcy at a certain time. For example, if you are accruing debt currently, or if you anticipate accruing debt in the near future. Generally, we recommend filing bankruptcy when debts have peaked. So if you know you're going to be accruing debt in the near future, you might want to wait. And this is because only debts that are on the bankruptcy petition, that are filed in the bankruptcy, can be discharged through that process. So you really want to include as many debts as you can. So all of the applicable debts are discharged through bankruptcy, and you have that fresh start. Um, it could also be a case where you may be behind on mortgage or car payments, and in that case, you might want to consider a Chapter 13. And again, it's a good idea to talk to a bankruptcy attorney to determine which um, option is best for you.
Great, thanks. We've talked about Chapter 7 bankruptcies a good amount now. I want to know, what are the costs involved in filing a Chapter 7 bankruptcy?
Good question. So the filing fee for a Chapter 7 bankruptcy right now is $338. Now, it is possible for a filing fee to be waived with permission from the bankruptcy court if you are very low income. But keep in mind, this is not very common, and you do need permission from the bankruptcy court. It is also possible to have that filing fee split up in 4 installment payments, again, with permission from the court. But in this case, you will need to have that full filing fee paid by the end of the bankruptcy case. So if you are concerned about the filing fee, again, it's a good idea to talk to your bankruptcy attorney about your options with the filing fee. Now, attorneys' fees vary widely, and there are several factors that are considered, including the complexity of the case. So you will need to speak with an individual bankruptcy attorney for a fee estimate. And this is typically done during that initial consultation when you're just deciding and you're not sure about somebody yet, but you're discussing their services. Chapter 7 bankruptcies oftentimes cost between $1,800 and $2,300, but again, attorney's fees can vary considerably, can be more or less depending on a variety of circumstances. So it is a good idea to get a fee estimate and maybe talk to multiple people if you are deciding between attorneys for bankruptcy.
Great. And we've also talked about certain debts being able to be discharged by a bankruptcy. And I just want to circle back to that. What kinds of debts specifically can be discharged in bankruptcy?
So that's a good question. And there are a lot. Most unsecured debts, like credit card debts, for example, those are very common. Utility debts, medical debts, these debts typically can be discharged in a bankruptcy. Um, Now, debts that can't be discharged, on the other hand, there are very specific types of debts that cannot go through a Chapter 7 bankruptcy. For example, there's certain domestic obligations like money owed for child support or alimony. Some tax debt, again, speak with your bankruptcy attorney about which debts can be discharged. Um, Debts that were not on your bankruptcy petition, again, anything that you've accrued afterwards, or if you hadn't put those debts on your petition, they cannot be discharged through that bankruptcy. Um, the same goes for loans that were obtained through fraud or debts that come from larceny or embezzlement. Some student loan debt, and this depends again on the circumstances. So if you have questions about student loan debt, speak with an attorney. Um, Also, debts that result from criminal acts, such as driving under the influence, cannot be discharged. Same with debts owed to a pension or profit sharing plan. And then there's some recent gifts to family or friends or luxury expenses that are incurred shortly before the bankruptcy case is filed. And again, this is situation dependent. Speak with a bankruptcy attorney about which debts can or can't be discharged, and they can give you a clearer picture based on your personal circumstances. Yep,
Great, thanks. Would I be able to keep my car if I filed a Chapter 7 bankruptcy?
that's a very good question. So you may be able to keep your vehicle in a Chapter 7 bankruptcy. Um, Exemption laws, as we mentioned briefly, they protect certain assets in a bankruptcy. And so if an asset fits within exemption limits, then it may be protected. If you've lived in Vermont for at least 2 years, you may be able to choose between Vermont exemption limits or federal exemption limits when you file bankruptcy. And if you've lived in Vermont for less than 2 years, you will need to adhere to the federal exemption limits. And each federal versus Vermont, they're both different, um, but they do cover assets such as vehicles, homes, all of that. Now, the Vermont limit for a vehicle is 2,500, and then the federal limit for a vehicle is $4,450. There are other exemptions to consider, but again, the bankruptcy attorney will be able to plan accordingly and give you the best benefit, and help you decide what is going to be best for your assets. Um, yeah, and there are additional exemption amounts that you may be able to apply if you have unused exemptions. Um, and also keep in mind that the exemption limits apply to the equity of the assets you own. So not the total value amount, but the amount that you actually own in the property. Now, in some cases, if you are making payments on a vehicle, um, and you're up to date on payments, you want to continue making these payments, you may be able to have a reaffirmation agreement. Um, this must be approved from the creditor and the bankruptcy court, but this is an option if you want to continue to pay on a car loan after the bankruptcy case is completed. And then on the day that you file, once you file your bankruptcy petition, there is what we call an automatic stay. And this prevents the creditor from taking further collection action. Now, with a car, um, during this stay, the stay is temporary and a repossession cannot happen during the stay, but it is still possible if you are behind on car payments for a repossession to happen after the stay is complete, after that bankruptcy case is complete. Um, so, once again, it's best to speak with a bankruptcy attorney if you are concerned about individual asset protections, such as your car.
Great, excellent. So it really does seem like speaking with a bankruptcy attorney is best. How do I go about preparing for a meeting with an attorney? There seems to be a lot to organize or to get a handle of.
That's a good question. So the bankruptcy attorney is going to want to know when they first speak with you about your debts and finances. And so it's a good idea to make a list of first the creditors that you owe money to, and then how much you owe each creditor, and get that information as best you can. It's also a good idea to get a copy of your credit report. You can go into annualcreditreport.com, and that'll give you, a good overview, and that's one way to show what you're dealing with. You should gather recent tax returns, recent pay stubs, income records, 3 months of bank statements. All of these will give a good financial picture of what you're dealing with and what your finances are. Sometimes the bankruptcy attorney will have a questionnaire for you to fill out, um, or they'll ask you for certain documents, and want to see certain documents. So it's a good idea to get as much as you can in order before meeting with a bankruptcy attorney, so you can be best prepared for that meeting. Um, and just also make a list of assets that you own. It may take some time to gather all these documents, but it's going to be worth it in the end.
Excellent, thanks. So how long does a Chapter 7 bankruptcy usually take?
So the average time from filing to the closure of the case is about 4 to 6 months. Um, but again, this can vary, especially if it takes time to prepare for filing, meet with the bankruptcy attorney, um, and fill out paperwork. So, again, this can vary, but 4 to 6 months is the general ballpark estimate of how long it might take. And thank you for joining us in this first part of our video series. So stay tuned for upcoming videos. We will be discussing more in depth about the actual process of filing, as well as the aftermath of filing bankruptcy in future episodes.